This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria, we're in this together.
The City of Chandler, we're in this together.
Town of Queen Creek, we're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. Whether you're working from home or doing kindergarten from home, we want to remind you that we're in this together.
City of Tempe, we are in this together.
Good morning and welcome to our Virtual Fall HOA Academy in partnership with the neighborhood services from all over Arizona, together with the cities of Avondale, Chandler, Goodyear, Glendale, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe, and the town of Queen Creek. We have organized this special virtual HOA Academy, and we're going to be providing 4 classes this fall in this format with the Facebook Live and the question and answer period. And we came up with 4 really great classes that we hope will provide excellent free education for board members, managers, and homeowners who live in associations in Arizona. Our topics today are how to keep communities and residents safe in a COVID-19 world, and also what are the top 10 things you need to know about Arizona law, so that you are making sure that your communities are following all of the Arizona laws and that you need to be aware of. As always, we're also going to have a question and answer period at the end, and we've really mapped out our time today so that we make sure we have plenty of time to answer questions from everybody. My name is Beth Mulcahy, and I am the managing partner and senior attorney of the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed practicing community association law for the past 23 years, and our law firm currently represents over 1,000 community associations, planned communities, and condominiums throughout the state of Arizona. And in addition to my experience of over 20 years representing associations, I've also served some hard time on my board over a decade, serving as a volunteer board member in my community where I live. Well, let's start out by saying welcome to our Fall Virtual HOA Academy, and it's in partnership with the neighborhood services from all over Arizona. So I'd like to do a special shout out for the neighborhood services from the cities of Avondale, Chandler, Gilbert, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, Tempe, and the town of Queen Creek. Together, all of us have organized a special virtual HOA Academy for you here today. And this fall's HOA Academy, of course, looks very different because it's not in person. We've tried to pivot and create really wonderful programming for all of these different neighborhood services departments throughout the Valley of the Sun and throughout Arizona, so that we could provide you with education on Facebook Live here today. And we're going to be able to answer your questions just like we may have answered those questions in the past. So thank you for tuning in today. Okay, let's get started here. First, I'd like to just start out by thanking these different neighborhood services departments for creating this programming. We're really honored as a firm to work with wonderful representatives from neighborhood services across the Valley year after year, and I can't thank them enough. I've been partnering with many different cities for over a decade to provide free education to board members, managers, and homeowners so that they can successfully run their associations. And the way that we're doing this is through these wonderful neighborhood services departments that are, being a conduit to provide the free education to their residents. So I'd like to just start out by thanking them for partnering with our firm to provide this education for all of you. Many of these neighborhood services departments realize how important education and teamwork is. And year after year, they create a curriculum that is interesting and that provides residents with the information that they need to succeed. And this fall, HOA Academy is no exception. We really put a lot of time together in creating the curriculum for today so that we could provide you with the most relevant hot topics that you need to know right now. We understand that a lot of you are missing the informative and lively in-person classes, but with the pandemic, the representatives from the respective neighborhood services and our firm met together back in March, and we came up with a plan as to how we can provide this education to all of you. And we wanted to show the residents that all of us are in this together. Previously, many of the neighborhood services departments were not partnering to provide unified education to all of these different cities. But during the pandemic, we all got together and we had a Zoom meeting, and we discussed providing education as a united front to all of our different residents. And as you can see, we have over 45 people here today. And so it's wonderful that many of these different neighborhood services departments are coming together. So we're missing seeing you and answering your questions and learning from you, but we're hoping that today we can all share some information and have a great interactive session. We understand right now more than ever that board members have a lot of questions, and community managers and homeowners, and you need to have information as we try to navigate the new normal and confront today's challenges. And we want to make it easy for you by providing this education to you from the comfort of your own home. And you can either log in live, or you can log in later and watch the videos via our website at mulcahylawfirm.com. And I have heard feedback from some people over the past few weeks that it would be helpful if we had an alternate time too for the classes. So when we do our spring programming, I can assure you that we'll have a variety of times. We'll have some evening classes and we'll have some day classes to accommodate everybody. And again, all these classes are always posted on our website a very short time after the class actually occurs. Okay, so this is our first class of our series of 5 classes this fall. Thank you to everyone who's made this series possible, and we look forward to working together as we teach these 5 classes to provide good information, cutting-edge information to all the residents. And so we just want to remind everybody that we're all in this together and we're better together, and these classes are really a great example of that coming together. Okay, so let's start out with our COVID-19 update. Earlier this summer, the Community Associations Institute produced an article entitled Healthy Communities. And this was just a really great publication. The national chapter of the Community Associations Institute has done an outstanding job providing education to residents, board members, managers during the COVID-19 pandemic. And so this publication, we have it in our comments section, so you can take a look at it too. I thought this was just a really great summary of some things that boards should have on their radars, managers should have on their radars, as we're navigating how to keep our communities healthy. And so some things some big takeaways or key takeaways from this handout that I will just address quickly that are really important in this new COVID-19 world to keep our communities healthy and safe would be, number 1, communicate regularly. Boards that communicate the best have the fewest problems, no question about it. And so during this difficult time, make sure that you're communicating with your residents about government orders that may impact the community. When residents or employees, if you have employees, test positive for COVID-19, making sure that you're getting the word out to your community so that you don't have a community outbreak. When your amenities are closing and opening, and why. Many times people want to know the answers as why it's closing. Providing candid and honest information to your residents is more important than ever right now. And also having virtual meetings, making sure that your associations are still conducting meetings, doing them virtually. And the ways that you can get the word out are by using social media and having prominently displayed posters around your community, if that's a way that you communicate, or sending out emails to your residents, putting it in your newsletter, talking about it at your virtual meetings. These are all really great communication tools. So first suggestion to have a healthy community, make sure that you're communicating to your residents often regarding the different things that are happening in your community. The second tip for a healthy community is cancel or postponing in-person activities and events during this time. I get copied on a lot of emails from different associations, and I was really surprised this morning and I was copied on an email from a large association in the West Valley, and they were announcing all of their in-person meetings for the rest, of the month. And I, was concerned about that because I know this is a 55 and over community, and that's an at-risk population for sure. And so our firm's recommendation right now is to, cancel or postpone the in-person activities and events within your community. If you can have a socially distanced event, and we've had a couple clients that have come to us and had proposals that we felt were safe, and we suggested that they run them by proper government authorities to make sure that, there wouldn't be any issues with them. But for the most part, you shouldn't be hosting bridge at the clubhouse because it's difficult to have social distancing. And, there's a number of other events, in different associations. Every association is different, but really think long and hard about in-person activities and events in your communities right now, because the threat of a community outbreak is real, and we've seen it in a number of communities in Arizona, and we don't want that to be your community. Instead, think about using virtual board meetings, committee meetings. If you haven't had your annual meeting yet, in this year in 2020, you must have your annual meeting conducted in 2020. We're going to talk about that in a minute. But use the virtual technology that's available. You can use a conference call if that's easiest for your association to conduct your meetings, or actually have a virtual meeting by using Zoom or another platform that your association prefers. And if your association needs any help on doing that, please reach out to our firm. We are here to help you. We can help you set up your first Zoom meeting. We can walk you through it. We can do training. And we can actually help you run your annual meeting if you need us to. And we've done that for a number of associations over the past few months. Limit traffic in enclosed spaces is another way to have a healthy community. If you have elevators, some associations are putting a sign at the elevator saying, don't enter the elevator if somebody else is in there, unless you're invited to do so. Requiring people wear masks when on the common areas, in the pool areas, providing soap, hand sanitizer, disinfecting wipes to residents and employees, having adequate ventilation and airflow in any shared rooms, cleaning and disinfecting all shared areas and frequently touched surfaces. And then there's going to have to be some extra precautions in the high touch areas or the high impact areas in your community, such as laundry rooms, activity rooms, exercise facilities, gazebos, benches, playgrounds, tot lots, tennis courts, pickleball courts, picnic tables, pools, hot tubs, water playgrounds. Not to overwhelm you, but you should be thinking about extra precautions and what type of signage you may need in those areas to ensure that residents are aware of what sort of cleaning procedures you have in place. And then don't forget, if you have an on-site office for your association, making sure that you have a safe business operations plan in place. If you have an on-site office or if you have a management company, what we're seeing with a lot of management companies is they have a flexible policy for employees. Maybe they're allowing them to work from home. They're having social distancing. They're using those plexiglass barriers to protect any employees that they have. So when they're interacting with others, such as residents in the community, they're able to, be safe. Okay, let's switch gears now that we've covered what the really excellent CAI publication was on this. Let's talk a little bit about what's going on in Arizona right now. On August 27th, the Arizona Department of Health and Safety announced that Maricopa County has moved into the moderate transmission category, which is great news for Maricopa County. And meeting this benchmark allowed for the phased reopening of businesses, including gyms and fitness centers in associations. And it's our law firm's position that before associations reopen the doors of gyms and fitness centers, we are highly recommending that the associations complete the attestation form, which the Department of Health Services in Arizona has placed on their website. And what you're doing with the attestation form is that the association is, confirming and asserting that they're going to comply with the self-operating guidelines. And we're going to talk about the self-operating guidelines just here in a minute. I had I think in the last week and a half or so, there was another law firm that practices in the area of association law, and they had put out a communication that said that they didn't believe that the associations needed to comply with the attestation form if they had a gym and they wanted to reopen, or a fitness center and they wanted to reopen. But there had been no official statement by the governor's office or by the Department of Health Safety at that point. And so we take a really conservative approach in our firm, and we suggested that anybody who has a gym or fitness center in an association, when they reopen it, they should fill out the attestation form. And we had a number of associations that did do this, and we quickly realized that this is kind of a box checker type thing. And by that, I mean that when they filled out the form and submitted it to the Arizona Department of Health Safety, they got an automated response back immediately saying that it had been accepted. And so we think it's best just to fill the form out if you're, waiting to do that, to reopen your gym or whatever. And it also gives you some, excellent suggestions on, a safe way to reopen your gyms. And so in the comment sections of the video that we have here today, we've posted a link for the Department of Health Safety services, their requirements for the opening of indoor gyms and fitness and club centers. And so let's just go over those requirements really quickly to make sure that everybody is complying with them. And again, you have to certify that you're doing this on the attestation form. First, you have to have limited occupancy, so 25% maximum capacity while we're still in the moderate category in Maricopa County. You need to have hand hygiene and respiratory etiquette discussed. Typically, that's going to be in your signage at the entrance to the gym or fitness center. Enhanced cleaning, proper ventilation, symptom screening, physical distancing, masks, communal spaces need to be closed. And associations need to take measures to ensure that its practices and policies meet these requirements and hopefully exceed them. And so if the associations cannot meet the safety requirements, gyms and fitness centers should not reopen right now. And so a common question that I got last week was, well, our association, we don't have, the staff to have somebody 24/7 in the gym, doing symptom screening. So how do we handle that? So what we suggest is in your signage that you have posted in, the entrance to the gym or the fitness center, that you make a comment such as, if you are feeling ill, or if you have a fever over 101, or, whatever the different symptom checks you're going to have, do not enter the gym. So you place the onus on that on the owners or the residents before they enter the gym. That would be the way to ensure that they don't have the symptoms. Okay, let's talk a little bit about our cheat sheet that our firm has put out. We have a wonderful new publication called Associations and COVID-19, a plan for reopening HOA and condo common areas. We updated that again last week, and it's going to be posted in the comments section. And this is the most up-to-date handout out there on the reopening plan for associations. A lot of language for signage and a lot of different considerations that your board should be taking as you reopen each amenity are listed in there. So I would highly encourage you to continue to look at that, and we'll continue to update it as the state changes their requirements as we navigate our way through the pandemic. Okay, reopening. If anybody has questions, anybody in the audience here today has questions regarding reopening the common areas, please feel free to reach out to our firm. We're here to help you, and you're welcome to email me or call me at 602-241-1093, and we stand ready to answer any questions that you may have on reopening. Okay, let's just do a parting thought before we move on from COVID-19. Let's talk a little bit about virtual meetings. And, some associations are just dove headfirst into the pool and have been conducting virtual meetings and are, up and running and finding a lot of benefits of virtual meetings. And one of our upcoming classes that we're going to be teaching through these neighborhood services HOA academies is we're going to talk about what are some silver linings from the pandemic. And definitely one of them has been being able to have meetings virtually. And what are the positives of that? And so just a quick point on that, we found that virtual meetings are ending faster than in-person meetings. we found that we've had a higher attendance of residents attending the virtual meetings and participating. And we found that we can get board members now from, that may not live on the property, that may not have been able to be there in person previously. They're now volunteering to be on the board. Maybe they live in Canada part of the year, or maybe they have a different home somewhere else in the valley and they weren't able to come to the meetings before, or they felt that they weren't able to volunteer to be on the board before, but now we're seeing some new life and some fresh faces at the meetings. And so that's a really good thing. I think we can all agree that the pandemic changed how we do business. I'm attending Zoom meetings frequently now in the evenings, and I don't have the travel time, so I'm not as far away or as gone as long from my family, so I'm enjoying that. But also, I think board members are really enjoying the ease of it. So once they get up and running using the conference call or using the Zoom to have their board meetings, they're finding that it's a plus for their community. So that's great. As health officials encourage us to, continue to social distance, and we don't have a vaccination yet in our country, we strongly suggest that the boards continue to hold meetings virtually. And in-person meetings are still not recommended by our firm at this time. And if you're struggling with the concept of the virtual meetings, we're here to help you. So we have a cheat sheet called Tips for Conducting Virtual Board Meetings, and that will be pinned in our comment section of this video. And it also can be found on our firm's website. And so if you haven't, crossed over and started doing virtual meetings, you may want to consider looking at that cheat sheet now. And it gives you some excellent suggestions. And again, our firm can help you with getting up and running. If you want to have a conference call, board meeting, or a Zoom board meeting, annual meeting, committee meetings, we can do training for you if you need help on that. But your boards really should be transitioning now to doing that, at least through the end of the year, until we know more about how the pandemic is going to play out for all of our communities. Okay, let's switch gears now and talk a little bit about what are the top 10 things you need to know about Arizona law pertaining to associations, condominiums, and planned communities. Before I get started, it's really hard to whittle it down to, 10 things. So what I tried to do is take that, based upon my experience, what are 10 things that I would want board members to know as they're serving on their board, or as they are, starting their service to their community as a board member, or maybe manager who's listening in here today. What are the things that I think are the biggest trip-ups or the biggest mistakes that boards make? And there's one that's going to be missing here today, because we're doing a special seminar just on this in one of our future 5, classes that we're teaching. That's the open meeting law. So I'm not going to spend a lot of time talking about the open meeting law today. I'm just going to say that this is definitely something that's important. And if you're a new board member, you definitely should be tuning into our special class and our special class that we're going to be having here as part of our 5-class series just on board meetings. Okay, so let's start out with number 1. What's the first thing that I think is really important for associations to know? I think the way to describe this best is which laws apply to your association. There are a number of laws that apply to associations, and it's difficult to navigate. When you get elected to your board, we recognize you have not spent your entire life prior to your board service getting ready to be on the board. You've probably had a different career, or maybe you had different hobbies or interests. And this is just a volunteer gig that you have signed up for to help your community. And it may even be because no one else volunteered. And so, the first thing I want to say is, hey, there are laws that apply to associations, and it's important that you're at least familiar with these laws. And so the first thing that I'm going to start out by saying is it's important to figure out what type of association you are. And so generally speaking, there are 2 types of associations. There's condominiums and planned communities in Arizona. And if you're a condominium, the way that you know you are, usually you can just look at the building. You can say, oh yeah, I'm a condominium. We have, 6 units in one building, and I'm considered a condominium. But really there's a legal way to determine that too. And the legal way to determine that is who owns the common areas. So let's say you have 100 owners or 100 units in your condominium, and each owner owns a 1/100th interest in the common elements or the common areas for your community. And that's how you know specifically if you're a condominium. So the owners share ownership interest in relation to the number of units in your association. And that ownership interest is in the common elements. So each person owns their percentage share of the common elements. Now, in contrast, if you're a planned community, a lot of times people will say, well, I know I'm a planned community. I just look at it. It's a freestanding house. I don't have any shared walls with any neighbors. Of course, that's one way to do it. But the legal way to determine if you're a planned community is to determine if the association owns the common areas. And if the association does own the common areas, there'll be a deed that has been recorded with the Maricopa County Recorder's Office, showing that the association owns Tract A, Tract B, Tract C, whatever. And also you'll be paying property taxes on that tract. So that's important to know. So the first question is, which laws apply to my association? How do you know? You first have to look at your documents to see who owns the common areas. That would be an important thing from my perspective. Okay, so then which laws are going to apply? Well, if you're a condominium, the Condominium Act in Arizona is a special act that applies just to condominiums, and it's significantly longer than the Planned Communities Act. On the flip side, the Planned Communities Act only applies to planned communities, and it's actually significantly shorter. And I really don't have an explanation for that other than there is, more regulation by an association typically in a condo, and condos have been around longer in Arizona, frankly. The predecessor to the Condominium Act was a Horizontal Property Regime Act in Arizona, and of course that was, no longer something that we look to, but so that's been around a lot longer than the Planned Communities Act has been, and that kind of explains to the evolution of, how real estate and properties, were formed and built in Arizona. Okay, so if you're a Condo Act applies to you. If you're a planned community, Planned Communities Act applies to you. And we have a cheat sheet that tells you where you can find these laws on Google if you Google the information. The cheat sheet is our board member roles and responsibilities cheat sheet. And that is going to be pinned in the messages section so that you can take a look at it. And it'll give you the direct links that you can, or the keywords that you can use if you do a Google search to obtain, information on these laws. Now, one other thing I want to mention is there's also another law that we use called the Nonprofit Corporation Act, and that's considered kind of a gap filler. And so most associations in Arizona, so if you're a condominium or a planned community, most associations are formed as a nonprofit corporation. And I'd say, if I had to guess, 99.999% of associations are formed in this matter. And so you also are subject to the Nonprofit Corporation Act. However, we don't use it that often because usually the answers that we are looking for an association, like what is a quorum or how do we remove a director from office, those are usually in our association's governing documents, in our CC&Rs, our bylaws, our articles of incorporation, or they're in the Nonprofit Corporation, or they're in the Planned Communities Act or the Condominium Act, okay? And so the only time we're really using the Nonprofit Corporation Act is when we can't find the answer anywhere else. And in that case, then we'll look to the Nonprofit Corporation Act to give us some advice. So important for you to know that the laws that apply to your associations are the Planned Communities Act or the Condominium Act. You can't be both. You're either one or the other, and then the Nonprofit Corporation Act applies to both condos and planned communities. Just a parting thought, associations are also subject to federal laws, and we're going to be talking about those federal laws in an upcoming class that we have for you. And we also have a cheat sheet on federal laws that it would be good for you to look at when we teach that class. Okay, number one, what type of association are you, and what laws apply to you? Number two, fiduciary duty. This is the most important thing that we will be discussing today. So I want you to make sure that this is something that you remember for, when you look back on this class today. So fiduciary duty, this actually is something that is in the Nonprofit Corporation Act. And it talks about what your duties are to the corporation when you're elected to the board. And so there's three main duties that you need to be aware of. You have a duty of care, a duty of confidentiality, and a duty to avoid conflicts of interest. So probably in terms of the most important, duty that you have as a director to a nonprofit corporation is your duty of care. And that means that you have to do due diligence as a board member. You should be showing up to board meetings. You should be pre-reading the board packet before the board meeting. You should be making decisions after, looking at the different, bids that you're obtaining, and making good decisions after having a careful examination of the facts and, the information that's being presented to you. And so having a duty of care would be if you're having, you're renovating your clubhouse and you're going to be spending $250,000 to do that, obtaining multiple bids, making sure that you're checking the references of the contractors and checking to make sure that they, don't have any issues with the Arizona Register of Contractors. Just doing, due diligence and care. Listening to your trusted advisors, your management company, your insurance agent, your attorney for your association. All these different trusted advisors that are here to help you and to help you make good decisions. So that's part of your duty of care. The next duty we're going to talk about is the duty of confidentiality. As a board member in a community, I think one of the things that's most surprising to people is you really get the juicy scoop on a lot of things going on in your association. And so you have a duty to keep confidential items confidential. And typically what that means is anything that you're discussing in executive session, you should not be discussing with anybody outside of the board or anybody who wasn't there at the executive session meeting. So let's say your attorney's there or maybe your manager's there. So you're going to be getting the juicy scoop and you're going to be finding out information about owners. Different things will come up over the time that you're on the board. And you need to keep things confidential, especially things like maybe if your attorney is recommending a settlement because the association's made a mistake on something and we're trying to, rectify that, making sure that you're not, telling others so that it might get back to the person who's suing the association. And this includes your spouse. You shouldn't be talking about executive session items ever with your spouse or with your walking group or your friends in the neighborhood. That's off limits, and that is your duty of confidentiality. Sometimes I hear from boards that they have a board member that has loose lips and they are telling, information about the association that is, obtained during the executive session. If that happens, you should get your attorney involved and we should talk about making sure that director and all directors sign a code of conduct so that everybody understands that, breaching confidences and, not keeping things confidential is ultimately hurting the corporation. And the last duty is a duty to avoid a conflict of interest, or self-dealing. So your boards, you should not be personally profiting from your time on the board. So, sometimes we see board members that are getting paid. That is very unusual and likely not proper. And so it would have to be in your documents that would allow a board to be paid, or maybe a board's getting a discount on their assessments. You shouldn't be doing that. And if you are right now, make sure that you're reaching out to our firm so that we can help you figure out how to fix that. So in this duty to avoid conflicts of interest or duty to, not have any self-dealing, it also extends to your family members. So it's a very bad idea to be hiring your son's, landscaping company to come and landscape the community. Keep things separate, as in any business would. Your nonprofit community association is just like any other corporation, and we have to follow corporate formalities. And so be real careful to not do anything during your time on the board where it could be perceived as, the decision you're making is going to give you a financial gain. That is something that should not be happening. Okay, so number 2, fiduciary duty, really important. Duty of care, duty of confidentiality, and duty to avoid conflicts of interest. Okay, we're going to go through the next few pretty quickly because these are just kind of short, things, but important things that you need to know about. So the next one is an audit, review, or compilation. So and this is listed on our top 10 cheat sheet that we have on our website, and it will be posted in our comment section here today. But both the Condominium Act and the Planned Communities Act require that the Board of Directors conduct an annual financial audit, review, or compilation of the association's books and records. And the annual audit, review, or compilation must be completed no later than 6 months after the end of each fiscal year. Most associations have a fiscal year end date of December 31st. And then if an owner wants to review those records, the audit, review, or compilation, the association has to provide it to them if they're requested within 30 days of it being completed. So I get a lot of questions on this. So do we have to have an audit? How do we know which one to pick? So let's just get right down to the basics on this. So the only time you have to have an audit done by a CPA is if it's in your documents, your association's documents, that you have to have an audit done annually by your CPA. If your documents are silent on this, which most are, if it's in your documents, it's typically going to be in your bylaws, possibly in your articles. But if it is in your documents that you are required to have an audit by a CPA every year, you must do that. If your documents are silent on an audit, review, or compilation, which we estimate probably 95% of associations in Arizona have nothing in their documents on this, then we suggest that you have an independent party conduct the audit, review, or compilation of the association's books to meet the requirements of this statute. Now, of course, the statute is super loosey-goosey. It doesn't say who can do the audit, review, or compilation unless it specifically says in your documents that the CPA has to do the audit. So who can do, the audit, review, or compilation? Well, like I said, it's loosey-goosey. Really, anybody could. Best practices would be to have somebody who's independent with financial experience and who is not part of the board or part of the management company, so that we actually have an independent look at the records. And so just keep that in mind as you're navigating that law. You do need to do that. A question I get often is, hey, we don't have... We haven't done this in the past, and we're just hearing about this for the first time on this live Facebook Live. So what I would suggest is going forward, please make an effort to do this. Don't look backwards at this time. So at the end of 2020, then you'll know 6 months after that you should have the audit, review, or compilation completed. And if you need a sample form, our office would be happy to provide it to you, saying that you've complied with this law. Just go ahead and email us or email me at bmulcahy@mulcahylawfirm.com, and we'll provide that to you at no charge. Okay, the next subject we're going to talk about is removing directors from office. A lot of people get confused about this, so I just want to spend a minute talking about it. We have the full summary of how to remove a director from office on our top 10 cheat sheet. It's number 6. And that has been, pinned here in the comments section, so you can, take a look at it at your leisure. Important thoughts about removal of directors from office. Number 1, state law trumps anything that's in your documents. So anything that's in your bylaws on removal of directors doesn't matter. You have to look at the state law. Another point I want to make is there's a very specific procedure that has to be followed. There has to be a petition. It has to be signed by a requisite number of owners in your community. We have to have a special meeting of the membership where there's a special quorum under the state law. And then you need a majority of those who attend in person or by absentee ballot to vote in favor of the removal. And recently, there's been kind of a couple updates to the state law regarding removal of directors, and it talks about how the removed director can be replaced. And all of that's on our cheat sheet, so make sure that you're taking a look at it. One other point I want to make is that if a director is removed from office, they cannot rerun as long as their term that they would have fulfilled if they hadn't been removed. They can't rerun for office during that time period. Again, that's all listed on our cheat sheet. One other point I'd like to make is that usually it's really difficult to get directors removed. So you should know that. So if you are a director that has received this removal petition and your board is going to have a removal meeting, in my experience, 95% of the removal efforts fail. So, and if they do fail trying to get you removed, they cannot try to remove you again during that term. So, interesting laws. And one other distinction I want to make: removal of a director is different than removal of an officer. So a removal of a director gets you totally off the board. So let's say that you are the president of your association and there's a petition to remove you as a director. If it's valid and they get the requisite votes at the removal meeting of the membership, you are off the board. You are no longer the president. You are no longer a director in your community. But there are some times where we have an officer in the community who's maybe gone rogue or who's not doing their job, and the board will come to our firm and ask us, how do we remove the officer from office? In your bylaws, there's typically a procedure that allows you to remove the officer just by a majority vote of the board. But remember, that officer, if they get their officer title stripped, they're still a director at large in your community. So they still are serving on the board. They just lost their title. Okay, number 5, fines and penalties. Remember that under Arizona law, an association can levy a fine against an owner for a violation of the declaration, bylaws, and rules of the community. We have to give notice of the violation, typically set up through a letter, and an opportunity to be heard, which can take the form of many different things. We can tell that the owner can write an email response or a mailed letter back to the board with their response, which would be their opportunity to be heard, and then we levy the fine. And something that boards mix up often is it's a process. You can't just send a letter. Like oftentimes I'll get an email, typically on the weekend, where a board will say, can you just send a letter levying a $200 fine for the RV that's been parked here all weekend? Well, we can't do that. So we have to set it up. We have to, is it a violation of the CC&Rs first? Check, yes. Then we send them a letter regarding the violation. We tell them that you're going to be fined on X date. We give them an opportunity to be heard during the time period before, they may be fined. And then we wait and we listen to see what type of response they have, and then we make a determination on the fine. So it's really a 3-step part. So we send a letter regarding the violation, we give them an opportunity to be heard, which is the second part, and then the third part is we make a decision as to whether or not the person's going to be fined. Now just remember on fines, it's kind of, they're hollow, and here's why. Because we used to be able to lien for unpaid fines many years ago. Now we have to obtain a judgment against the owner. Typically it's going to be in justice court because there's under $10,000 in dispute in the lawsuit for the fines. And so we have to take the step of obtaining a judgment in justice court to collect on the fines. So keep that in mind. The fines should be used as a strategy to get owners to pay their assessments. That's the key. The fine should be used as a strategy to get owners to correct their violation. Okay, that's the strategy here. We threaten the fine, we fine them to get them to fix whatever the violation is. And if they aren't fixing it, then of course, yes, we can, go the extra step of filing a lawsuit, but there's, legal fees that are going to be involved in that. So we're not going to do that for a $200 fine. We may have to file a lawsuit, get an injunctive relief lawsuit going in Superior Court to have the court order them to stop doing something or whatever. But remember that fines are a way to get, people to comply with the documents. And, if somebody complies in a reasonable time period and they're not a repeat offender, well, then you may want to consider lowering the fine or waiving it altogether. Okay, number 6, annual meetings. I put this one on here because this is kind of a special one during the pandemic. We've found that there are a lot of associations that didn't have their annual meeting in March, April, May, June, July, August. And we just want to remind everybody that there is a requirement to have an annual meeting every year, and that requirement is in the Nonprofit Corporation Act. And if you need help with the annual meeting, make sure you're checking out our annual meeting cheat sheet, which is posted in our feed here on the comments section. And also check out our virtual board meetings and annual meetings, our new cheat sheet on that. And we're here to help if you need any help. Okay, collecting delinquent assessments. We're really waiting for the shoe to drop on this, but we're monitoring very carefully what's going on in our state, in the national economy, and owners are still paying assessments right now. But we anticipate that in the first quarter of 2021, we're going to see a large uptick in the number of owners that are not paying assessments. And so we want you to be ready for that. So make sure you're looking at our cheat sheet on collecting delinquent assessments. We have some really great secrets that we share with you, and you want to be ready for that when the other shoe drops and people stop paying their assessments. The next number is number 8, rental properties. Wow, we are getting so many questions right now in our office about how do we deal with short-term rentals? What information can we ask a landlord owner to give us before, the tenant moves into the property? And so a really good refresher, if you're having those questions right now, look at our rental properties cheat sheet. And that's posted in the comments section here. And we'll tell you specifically what is the information that you can request from a landlord owner. And remember, we cannot request a copy of the lease. We can't make it mandatory that they give us a copy of the lease, but we can ask for different categories of information like the name of the tenant, what vehicles they drive, how long the lease is going to be, etc. And we can charge a small fee. So make sure that you're checking out our rental properties cheat sheet. Number 9, there are certain state filings and federal filings that you have to file each year. And we want to make sure that those are on your radar, especially if you're a self-managed association listening here today. So first, taxes, right? Everybody has to pay taxes, including associations. So all associations in Arizona must file state of Arizona taxes and federal taxes. And those taxes are filed on March 15th each year. If you're an association that's listening in here today and you have never filed state or federal taxes, start doing it in 2021 for the 2020 fiscal year. So you want to keep that on your radar. You should have a CPA or somebody with a lot of financial experience helping you with preparing the taxes. It's a very easy form. You usually do not owe anything, and it's just kind of a box checker. You have to do it every year. Also, if you're a planned community, you have to pay property taxes on your common areas. So make sure that you are paying the property taxes, because if you don't pay them, they'll be sold at a tax lien sale after several years of them not being paid. And then last but not least, this is the big one. Every year, associations have to file an annual report with the Arizona Corporation Commission. And this is only if you are a nonprofit corporation, but like I said earlier here today, 99% of associations are nonprofit corporations. So we put in the link here today, the comment section, a link to the Corporation Commission. You can go right to the Corporation Commission website, do a name search for your association, and see if you're in good standing. And it's a rolling filings on this, so they're throughout the year. It's not like all of them are due January 1st or April 15th or anything like that. So you'll want to check to see if your association is in fact filing that. And you can set up to get an email reminder to whoever, somebody who's on the board who is, going to have some longevity with the community. And they'll send a reminder 60 days before it's due. Now, one thing, if you're a client of our firm, every quarter, our firm does a free check for all of our clients to make sure that you're in good standing. And if you're not in good standing, we send you a letter to let you know. Okay, last but not least, what to expect in the legislature in 2021. Wow, this is going to be a big year. So 2020 was not a big year because the legislature was focused on passing the skinny budget quickly in March, and they really didn't get around to passing any HOA or condo related bills. So what do we think is going to happen this year? A great place to look as a starting point is what happened in 2020. And so go to our legislative summary from 2020 and look at all those bills that were introduced. And I think we can anticipate that these are the bills we're going to see reintroduced in 2021. And so we put in our comment section, we have a link to the legislative summary from 2020. Some key things that I think we're going to see in, the new legislative session, which will start in January of 2021, we're going to see something on short-term rentals. No question in my mind. There is going to be some sort of action, possibly to allow, cities and towns and municipalities to regulate short-term rentals. But I think the ban on having ordinances is something that likely will go away in 2021. Green bills, solar bills, anything that's good for, the earth, we see those every year. I think we can anticipate that we'll see those again. There was a bill last year on the ability to obtain attorney's fees on garnishments. I'm confident we'll see that bill again. Open meetings, there's always fine tuning that's done every year. The legislature on open meetings, I think we can predict that again. And then last year we saw kind of an oddball one that we hadn't seen before, giving the association the ability to have write-in candidates, which kind of is interesting because as someone who's in the trenches and attends a lot of meetings, I know that write-in candidates, they very rarely win because there really has to be a grassroots efforts to provide them, with a lot of voting support. And so if it's a write-in candidate, typically they're not printed on the ballot, right? And so people would have to know to write down their name and know that they're interested in running. So we don't see that very often, but it's just something that's notable. Okay, so let's go to our questions. We're good on time. So the first question is, and if you have any questions, now is the time to put them in the comment section. And I will do my very best to answer every question that comes up here today. The first one is from Michael. Can our board legally make a decision by email? They claim the nonprofit statutes allow, but I believe the condo statutes overrule. Okay, really great question. We're going to be talking more about this when we do our open meeting class coming up here in our series of classes for neighborhood services. But you're right, Michael. It's my opinion, too, that the Condominium Act and the Planned Communities Act, specifically the open meeting portions of those laws, overrides the Nonprofit Corporation Act, and boards should not be making decisions by email. Now, there are some exceptions to that. So just your regular board business, needs to be done during the open session of your board meetings. And during the pandemic, like I said, that's being done typically by conference call or by a virtual meeting by Zoom or whatever platform you're using. There are some exceptions. Boards can make decisions by email in emergency situations. And so we did see that, in March and April, we had a number of things that came up for associations and they had to make quick decisions. And emergency is typically characterized as 48 hours notice. You don't have time to give 48 hours notice. You need to make a decision quickly, promptly. And so we're advising our clients, do not use email to make your board decisions. It's okay to exchange information. So here's 3 bids for the tree trimmer. Let's discuss at the next meeting, or here's the meeting packet, or when can everybody meet this month? Those type of things are okay. But hiring and firing a new management company, discussing the tree trimming bids, that's a no-no. Now, there are a couple ways around this. Of course, you can have less than a quorum discussing things by email. That's fine. And again, like I said, if the full board is discussing something by email in an emergency situation, in my opinion, that's fine. Great question, Michael. Okay, next question. Mark, what do you find to be the best method of communication to residents? Blast emails, mailed letters, next door? Great question. I think blast emails seem to be, if you want to have the largest sweep of potential residents in your neighborhood. And of course, it depends on, do you have emails for people? And every association is different in terms of how advanced they are with technology. So from my experience, most boards are getting the word out by blast emails. But for some communities, putting it on the bulletin board, putting it in a newsletter, mailing, I would say, is kind of really dropping off. People, the only things that are being mailed now are things that were legally required to mail, like the annual meeting notice. Nextdoor, sometimes I have seen boards putting things on Nextdoor, and I think that's a great platform. If a board has a Facebook page, that's a great platform. I mean, there's a number of different ways you can get communication out, but the email seems to be the most popular. Neil, can an HOA board legally grant a free assessment quarter period due to coronavirus, which shut down the use of all amenities, such as playgrounds, basketball, and tennis courts for over 120 days? So this is a really good question. This is almost like a loaded question, so I have to be careful on this one. So as the HOA attorney or the condo attorney, I'm going to say that I'm really not advising boards to, do a fee reduction on the assessments or to grant a free assessment quarter at this time, because the association still has all of the expenses that they have always had, right? They still have their management company, they still have landscaping, they still have to take care of the amenities, even though they may not be in use the way that they used to. But I mean, you can't just let the pool go green, even though the pool may have been closed for a few months. So if you're an association that's thinking about doing this, make sure you reach out to your legal counsel. Really, the only way that this would even be a possible consideration is if your association has an excess in your budget for this fiscal year. But again, we're not advising our clients to do this. Joanna Loftus, community garage sales in the fall, good or bad idea? That's the first time I've heard this one. Good question, Joanna. I think it just depends. Like if you were going to do a community garage sale where some associations, block out kind of like a swap mart, where everybody's coming into your community and they're, booths and people are selling things that way, I think it's going to be really hard to comply with the current government orders of no more than 50 people meeting. And, even in the pools, the governor has ordered that, we should have no more groups of than 10 people in the pools congregating at one time. And so I'm going to err on the side of caution, unless there can really be heavy regulation of the social distancing and masks, probably not a good idea. Now, if you're having just a garage sale where people are having others come into the neighborhood and they're, everything's outside and they're requesting social distancing, maybe that works, masks and social distancing, maybe that's a concept that works. If they're just going to the individual owners' properties and everything's on the lawn, it's possible that could work. But again, you may not want to take that risk right now. We only have a few more months, hopefully, before the vaccine comes out. Maybe this is just the year that we don't do garage sales this year. Okay, there was a bill to modify or repeal the account statement law. Any likelihood this will be taken up again? Yes, definitely. I'm sorry I didn't mention that. That was something that is important. So last year, in 2019, there was new legislation that put a really heavy onerous on association management companies or the management companies that represented the associations to have a account statement sent to every owner. And you had to have a breakdown of the balance forward, et cetera. And it's really added an extra expense to many associations because it's just passed through to the association. So there were, I think, several bills in 2020 that were introduced on this, and I think we can definitely plan on seeing a bill on that in 2021. So really good question, Bill. Vicki, can you advise on guidelines for a management company? Ours has taken way too many liberties, and it's difficult to defer to the board. Great question. I taught a class very recently on this subject, and it's listed on our website at mulcahylawfirm.com. And I would encourage you to go back and listen to that class. And you can find it by going to the videos on our webpage at mulcahylawfirm.com. And we also have a cheat sheet called How to Select a Management Company. And we'll give you some tips on how to have a good relationship with your management company, how to know when the relationship is over, and how you can find a new management company if it's determined that the relationship is over. So Vicki, I hope you check that out because that'll be a good, really good response to your question. It'll be a detailed response. Heather, as a community that has a high long-term rental population, how would you suggest getting information to them to provide an inclusive environment? Okay, so you have a large number of rentals in your community, and you want to communicate with them so that they know about, the pool closures or anything that's COVID related that might pertain to them, or really any other matter pertaining to your community. Because let's face it, even though they're not an owner on the title of the property, they're residents and they're using the amenities, and maybe their landlord isn't getting the information to them in a timely manner. So I would suggest that maybe you have a separate residence list if you're sending out an email blast, and have the email blast go to a separate residence list with any information that's being broadcasted throughout your community. That's a great idea. Also making sure that it's posted. Any changes are posted in the common areas. You might even want to add them on a separate residence list, serve as people that should be getting, if you're mailing things, have a special mailing to them. I mean, it really is just going to depend on how many you have and how important it is to your community to make sure that the residents that are not owners are tuned in to what's going on in your community. Okay, so we are like almost on time, which is awesome. So thank you everybody for just some final words. Thank you so much for joining us here today. I think at one time we had well over 60 people who were tuning in here today, which is a really fabulous showing for our first Neighborhood Services HOA Academy this fall. I'd like to just remind you that we have 4 more classes coming up over September, October, and the beginning of November. And all of those classes and a complete schedule of those upcoming classes for the Fall HOA Academy can be found on our website at mulcahylawfirm.com. All you have to do is just click on our upcoming seminars tab, and they will all be listed there. And I just wish everybody all the best over the next few weeks until we meet again. And I'd like to just do a shout out again to the many different neighborhood services departments who have offered to have us teach these classes. Again, Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, Tempe, and the town of Queen Creek. Truly, together we're better when we can provide this type of programming to all of our residents. And so I just want to say thank you again for giving me this opportunity. And thank you, everybody, for joining us here today to make your communities better.
This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler, we're in this together.
Town of Queen Creek, we're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. Whether you're working from home or doing kindergarten from home, we want to remind you that we're in this together.
City of Tempe. We are in this together.